The next matter is Christina Millard versus John McDonough. The file number is 252682SC. This is a small claims matter. Ms. Millard is suing for $1,500 for money she says she paid for legal services and never got the services and never got the money returned. So I'm going to ask if you would both please raise your right hand. You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Mr. McDonough? You're on mute. I can't hear you.
Sorry, Your Honor. Yes, I do.
All right, very good. Let me explain. John, you probably understand all this, but Ms. Miller, this may be a little less familiar to you. We're in small claims court, and in such, the rules are different and more relaxed than general court. We don't strictly follow the rules of evidence or procedure. I will allow documents without a lot of supporting affidavit or that sort of thing, foundational requirements. But both parties are under oath. The claim is limited to $7,000. Neither party is allowed to have an attorney in small claims court. There's no formal record being made of the proceeding in small claims court. There is no appeal from small claims court. Any decision made here is final. Either party has the right to remove the matter from the small claims to the general division, as was just done in the last case, but you have to tell me that before we start. Ms. Millard, are you ready to proceed?
I am.
All right. And in your claim, you indicate that you retained Mr. McDonough when he was in private practice as an attorney to represent you in a divorce matter, and nothing was done and you never got your money back. Is that your contention?
That is correct.
Mr. McDonough, what's your position?
Well, I do remember having a lengthy meeting with Miss Millard, and I believe it was her mom who also came in to my office that afternoon. We met, we went through all of the information that was going to need to be required for a complaint for divorce. I kind of listened to what her story was and jotted everything down. Kind of prepared a template complaint for divorce that day, and then when I finished in the office that day, took the check and deposited it into my account, and shortly thereafter, I don't remember if it was the day after, she contacted me and talked to me about them potentially reconciling, but he had hired Jay Felt, and Jay Felt was potentially going to handle the case. And I told her that I would speak to Mr. Felt, which I did. And he explained to me that he thought he was handling their entire divorce. And at that point, I thought matters were settled. She had been explained what a retainer fee was, and that it wasn't something that she would be given back once she paid it. And I believe I followed my part of the bargain. She ended up dealing with this with Mr. Felt, but I certainly didn't have any intention of not following through with everything that she would have needed. It was my understanding that this matter was over and done with. And I don't know if there's a statute of limitations or not, but it's been nearly 3 years or 4 years since I heard anything.
The statute of limitations is 6 years.
Okay.
Uh,
This is my first dealing with
Small thing.
small claims as well, so.
All right, well, what she says, I paid a retention fee for services provided during my divorce. The check was cashed. I did not hear anything back. There was no work accomplished. Ms. Millard, did you sign any sort of retainer agreement or anything?
I did not sign any type of agreement with Mr. McDonough. Yes, initially I met with him a couple times actually, and we had like a consultation about what was going to happen. There was one point where my ex-husband and I thought that we would reconcile. So I asked if he could just put it on the back burner, just hang on to the money. And he said he would hang on to the money. It's not going anywhere. It's in a trust fund account. And then after that, we proceeded to continue with the divorce. And I was reaching out to Mr. McDonough, and he stopped replying to my text messages and my emails. And then I went to his physical office where he was, and they said that he didn't work there anymore and they couldn't tell me where he was. So it was just kind of all the communication was lost, and I just didn't hear anything back from that. So I just continued doing everything on my own with the divorce.
Did he file any pleadings or do anything else on your behalf?
No, he did not.
Did you ever get a chance to ask for the money back?
Well, that's in the text messages that I was sending to him when I was reaching out. I'm like, are you getting my emails? And it was just like no response whatsoever. And I couldn't find him. And at that point, it was just a lot of stress that I was going through at the time. So I just I was just going to let it go. But then recently I was thinking about it and I'm like, that's not really fair. He didn't really do any work for me. So why should he get to keep that money?
All right, Mr. McDonough, any last response?
No, my contention would be that some work was done, and that once I spoke to Mr. Felt, who I believe is the party in the divorce, and he told me that he was handling it for everyone, I kind of forgot about it.
All right, Miss Millard, you're the plaintiff. I'll give you the last word.
I think I said, oh, sorry.
All right. So you never got any response to any of your texts or emails or requests for your money back. Is that correct?
That is correct.
All right. The statute of limitations is 6 years. Apparently she let it pass and then decided that she didn't think it was fair. Essentially, Mr. McDonough got $1,500 for a consultation. There was no retainer agreement ever signed. She paid the money in good faith. Mr. McDonough said it was in a trust fund, which is where it's supposed to go. But he didn't do any work. But he did meet with the defendant on a couple of occasions. I'm going to allow some consideration for that. I'm going to order that you repay $1,000 plus 66.25 and 43.18. So the total is $1,109.43. I will allow $500 is pretty generous. I don't know what his hourly rate was, but he did perform some service in consulting with you and you paid the fee. He then discussed the matter with Mr. Felt and discussed it with you again, but no work was performed. I'm just going to do this judgment. It's due within 30 days, or you can pursue collection on this matter. I did allow some consideration, as I said, but 500 is probably generous for the amount of work done. He didn't respond to text or email messages and didn't refund the money. All right, $1,000 plus $109.43 of costs, which was $1,109.43. I guess we could do an installment. Mr. McDonough, could you pay an installment, or would you rather just try to pay it all at once?
I don't know. I need to figure it out.
All right, I'll just leave it as
Right
this.
now, the court's aware of that. So
Yes, I am aware. He's had some significant health problems that have prohibited his ability to work, but this money was not part of a signed retention agreement. All right, it's due within 30 days, or she can pursue other collection remedies, or you can agree on some sort of repayment. Ms. Millard, you're still at the Ramona Avenue address in Portage.
That's correct.
His address in Three Rivers is still correct. And I will send a copy of this. He has 30 days to pay it, or you can pursue what's called a discovery subpoena and compel him to come to court to talk about his ability to pay it. But knowing him, I believe he will pay the judgment.
where do I pay? I pay the court?
You pay directly to her. Her address is on the judgment. All right. We'll be
Okay.
in recess.
So I paid
All
1,100 and how much?
1109.43.
Hi, Judge. Do you
Hi.
intend to be on the record still?
Let me stop this.
Okay.
Thank you. All right, Miss Millard, best of luck.
Thank you.